Welcome back, everyone. So we are closing out with 2 sessions before the evening break, and our next session is on 510K, and what that means you're going to learn in just a little bit. But we are delighted that Justice David Wecht is our moderator for this program. Justice Wecht has been on the Supreme Court of Pennsylvania since 2016. Prior to that, he was a judge on the Allegheny County Court of Common Pleas, as well as the Pennsylvania Superior Court. He has his BA and his JD from Yale. And before entering the judiciary, he was in private practice as well as serving in a variety of other positions, including the Register of Wills and Clerk of the Orphans Court in Allegheny County. So Justice Wecht has promised us an exciting panel following our lunch to keep us awake. And so I turn it over to Justice Wecht.
Thank you very much, Professor Cochin. With his devilish sense of humor, Professor Cochin assigned me to moderate a panel in an area about which I know absolutely nothing. So there's probably not a single person in this room who knows less about 510K clearances than me. I just want to put that out there right now. I've heard of 401Ks. I've heard of 10Ks, both the security statements and the races, but never 510K. Anyway, we do, however, have 3 wonderful panelists who know everything about this area of law, and we're going to hear about this in the context of what information should flow to juries, and the panelists are going to relate to at least one particular case in which these matters have been litigated. I'm going to give a very brief identification of our panelists. There's much more information about them and their fine credentials in your materials on the agenda. Abigail Butler is a partner with Faegre, Biddle, and Reath. She's in their Fort Wayne, Indiana office, and Abigail resolves intellectual property and product liability litigation. I meant to ask her before we started. On her bio, it says she resolves intellectual property and product liability litigation. Most of the lawyers I know instigate such litigation.
I'm a defense lawyer. I don't instigate.
But she has a large variety of experiences litigating medical device cases, consumer products, as I said, intellectual property matters, and the like. Philip Goldberg is the managing partner and co-chair of the public policy practice group of Shook, Hardy, and Bacon, and he has many years of experience in public policy, public affairs, public relations. He counsels businesses and trade associations, has testified before Congress. Pity him, my goodness, that's got to be quite an experience. He's filed amicus briefs and has been involved in thinking about many of the issues posed in seminars like this one here today. Jonathan Orent is a partner in Motley Rice, L.L.C. I should say Phil's based here in D.C. and Jonathan's based in Providence, right?
That's right.
Yep. Jonathan litigates for people alleging harm by reason of defective medical devices and pharmaceuticals. He's been lead counsel on a number of major litigations, including the hernia mesh and pelvic mesh products you might have heard or read about, and also hearing loss cases involving military service members, defective earplug issues. So I'm just going to leave it at that because their backgrounds are too lengthy to recite further, but we'll start off with Abigail. We'll take like 12 minutes apiece, and then everybody gets rebuttal. And since I don't know anything about the area, I'm going to ask very few questions, and I know you'll all have a lot of great questions. And of course, Professor Cochin's always there to come in with thoughtful questions too.
All right, well, good afternoon, and thank you very much for the invitation to speak to you all today about this fascinating topic. I'm impressed. So many of you came back after lunch to talk about this. I know that it is very complicated, and it's something that even I, litigating almost exclusively now medical device product cases, that I don't I can go a couple years or more without even touching any federal preemption issues. So I am curious, how many of you have had the occasion to resolve or to make a determination involving federal preemption in your courtrooms? Yeah, well, see, you do know something.
Well, but not 510K.
Okay. How about involving a medical device? Do we have anyone? Okay. All right. So my fellow panelists asked me to speak to you just sort of generally, give you kind of the background with FDA regulatory process and how it works, just as kind of a primer. And so I'm just going to start out with that. All medical devices sold in the United States are regulated by FDA. They use a 3-tiered classification system. It's Class 1, Class 2, and Class 3. And FDA makes those determinations. It's not the device manufacturer making those determinations. FDA is the one that tells the business or the companies what class their products are going to be considered. And Class 1 medical devices, well, I should also say, too, these are classified according to risk to the patient. So Class 1 is considered to be the lowest risk to the patient. And products that fall into Class 1 are things like Band-Aids is a common one, forceps, tongue depressors, things like that. Those are not governed by the 510K process and the PMA process that you'll hear us talk about up here today. They are subject to general controls by FDA, but that's pretty much the extent of it. And almost half, the most recent number I saw was 47% of medical devices fall into Class 1 today. Class 2 medical devices are those that pose a moderate risk to the patient or the user, and approximately 43% of medical devices are going to fall under this category. Examples of Class 2 medical devices that you might encounter would be syringes, blood pressure cuffs, and pregnancy test kits. I had to kind of laugh when I looked that up because I thought, I can see on a syringe might pose some harm, but I'm not really sure how a pregnancy test or a blood pressure cuff could hurt someone, but that is how they're classified. Class 2 medical devices are typically regulated through something called the 510K clearance process. There's some difference in opinion as to how stringent that process really is. You'll often hear plaintiffs' lawyers refer to the 510K process as a loophole, and they'll emphasize that a clearance is not tantamount to an approval. And that is what you get. You walk away with a 510K clearance to market the product. It's not an approval from the FDA, and that's something that you'll hear the lawyers talk about in court all of the time. Well, if you let it in. And it is true that the 510K process does not focus on safety and efficacy in the same way that a PMA process does, and I'll talk about that in a minute. It focuses on substantial equivalence, and it asks the question of whether the device at issue is as safe and effective as one that is legally marketed in the United States. And so what the FDA is doing is they're drawing on a long history with substantially similar or substantially equivalent products. And I do want to just interject with a personal viewpoint here, and you'll take it for what it's worth because I am a defense attorney when I say this, but I have had the opportunity to meet and work with a lot of former FDA reviewers. Yes, they were my paid expert or my client's paid expert, but I have been extremely impressed with each and every one of them. They're smart, they're caring, and they're hardworking. And they wholeheartedly believe that for products going through the 510K pathway, they have enough information available to them to make the necessary determinations. They certainly don't consider the 510K process a loophole. If they feel they need additional information, they will ask for it. They typically sit on a panel with other experts in the area, and they can bounce ideas off each other. They have a wide amount of information available to them to make that determination. So, in short, they've given me confidence personally in the system. And then finally, there are Class 3 devices, and those are the devices that pose a high risk to the patient. They're usually used to sustain or support life. They can include pacemakers, implantable devices, ventilators. They represent less than 10% of medical devices regulated by FDA. Unless grandfathered in, a Class 3 medical device will come to market through the pre-market approval process. This represents a true approval by FDA, which requires clinical and laboratory studies, and a detailed review is conducted to ensure safety and efficacy. The PMA process requires manufacturers to provide the FDA with reasonable assurance that the device is both safe and effective. And as a result, after approval is granted, manufacturers are prohibited from deviating from these processes in any way that could affect the safety or efficacy of the device. And when we talk about federal preemption in the context of medical device cases, most people think about PMA devices, and that is by and large the most common scenario in which you will see preemption being discussed and considered. There is something called 510K preemption, which I think maybe Phil might talk with you a little bit about today, but I'm going to focus my comments on PMA preemption. In my 20-ish years of practice, I'm saying 20-ish now, I have only had 2 PMA products come across my desk. And I'm actually handling one right now. And that's kind of made me more passionate about the topic, I guess, right now, because it's something that's actually on my desk that I'm working on. But I have a PMA product right now. And when it came in, I was so excited. I thought, oh, this is going to be a slam dunk. We're going to get rid of this case. I got my client all excited. So I constantly am hearing questions about, when can we get out of this case? We're not going to have to do discovery, are we? Well, we certainly won't have to do experts, will we? You know, she's very excited. I was very excited, too. So when I started preparing my preemption motion, I noticed the plaintiff had cited a case, a Seventh Circuit case, within the complaint itself. And I don't know if any of you have heard it, Bausch versus Stryker. You know about it because we talked about it. I never heard of it. I mean, like I said, I've only handled 2 PMA devices so far in my career, so I took a look at it, and that case could present a real problem for me and for my client. So my opponent was very smart in what he did. So he read this case, and he cited it in here. He knew that he had a PMA product that he was dealing with. In fact, I told him that from the very beginning. I called him. I was so bullish. I called him, and I said, what are you doing? This is a PMA product. Like, just dismiss it. And he's like, no, I'm not going to do that. So what he did was he cited a laundry list of federal regulations, CFR regulations, that he alleges our client violated. And he is using the Bausch case as support that those claims are not actually preempted. The alleged violations are, like I said, they're 21 CFR Part 820. And if any of you have ever looked at those regulations, they're not very specific. They're very general. They give the manufacturer a wide amount of autonomy to decide, how they're going to comply with those. Bausch is from 2010, so if that tells you anything, it's still good law. It's been criticized and distinguished a couple of times. That's it. So that's another clue right there that we don't deal with this topic very, very often. But it's out of the Court of Appeals for the Seventh Circuit, and it created a direct circuit split over the extent of PMA preemption. It does remain good law today. The overall holding of Bausch is fairly narrow because it does affirm the dismissal of everything in the case other than these so-called parallel violation claims. But Bausch says that a failure to comply with a federal regulation may give rise to a state law claim that is not preempted, regardless of the PMA status. After reading that case probably 25 times, I believe I have a cautionary tale related to the case. I have not done my own independent research on this, but I'm going to because I need to deal with this case in my own case. But the cautionary tale I want to leave you with is that there was an assumption in that case by both the court and the parties that there was actually a parallel state court claim. I don't think there was. And I think that is something that we cannot take for granted. Just make sure of that before going down this path. A few years later, after Bausch, the Ninth Circuit in Stengel versus Medtronic issued a broad ruling that failure to report adverse events required by federal law could be used to support a state law failure to warn claim under Arizona law. The Ninth Circuit cited to Bausch as persuasive authority. It took a few years, but then the Supreme Court came out and said, no, there is no duty under Arizona law to warn a governmental regulatory agent, and a failure to warn claim has nothing to do with an obligation to relay information to a third party. So the other thing that struck me too, I know we're supposed to be talking about admissibility at trial. One thing that kind of struck me is if we're going to go down this path, and we had a trial where the plaintiff was claiming all of these federal law violations, I think the way that evidence would likely come in is through paid experts on both sides, I would think. And you're talking about very general CFR regulations. So you're going to have paid experts on both sides talking about what's required under these regulations. And it's a question of law as to whether or not, it's a question of law as to what the regulation requires, but the jury will decide whether it has been complied with, and they'll also have to decide whether or not that failure to comply caused the plaintiff's injuries. And that's another big thing that we can't forget here, is that there still has to be that violation or that failure to comply with the regulation has to be linked up to the plaintiff's damages, which I think would be very difficult to do. I also feel like having experts on both sides talk about that, it kind of reminds me of the word that you always see bandied about in the 510K question about whether or not that evidence comes in, sideshow, right? That's what I was thinking of, is just the sideshow with these two experts talking about what these FDA regulations require and whether they were met. And that's a topic that my fellow panelists will be addressing, including a new state court case coming out of New Jersey that analyzed the issue and, in my opinion, got it right.
Jonathan, pardon me before you start. I just wanted to give people the site for the Bausch case that Abigail was talking about. It's Bausch, B-A-U-S-C-H versus Stryker, S-T-R-Y-K-E-R Corporation, and the site is 630 F 3rd 546 7th Circuit 2010, and it was a diversity case. And I just wanted to add to what Abigail said that. And this is why the case may be an outlier, or one of the reasons that there was a bad hip implant case, diversity case, negligence and strict products, but 6 days after the FDA informed the defendants that a component of their hip system was adulterated is a term of art here that it is a red flag for FDA. The hip device was implanted in the plaintiff. Yeah. So it's, the case is a bit of a,
yep.
Just wanted to add that.
Bad facts make bad law sometimes. Yeah.
Sorry, Jonathan.
First of all, I want to pick up where you left off. Were you talking about the Himrock?
Yes.
I will never know exactly how to pronounce that case.
Just go to McGinnis, it's a lot easier.
Yeah, exactly. So I think I'm going to talk a little bit about this notion, first of all, of the PMA cases, right? So the FDA cases that have been preempted in lawsuits are largely those cases where there is a risk of a jury deciding an issue in a different way than the FDA has. The policy consideration is we don't want juries concluding that a drug is safe and effective or a device is safe and effective if that's what the FDA has found. And so for that reason, investigation by a jury is very limited into the PMA Class 3 area where a determination of safety and efficacy has been made, okay? And I'll come back to where those exceptions lie. But that leaves us into the Class 2 and Class 1 areas where the FDA does not make such a classification, right? So there is no jury review of a finding of safety and efficacy related to, there's no jury consideration of an FDA's finding of safety and efficacy that could be found to the contrary. And that's because the standard that's used by the Class 2 devices, by and large, and there's an exception called de novo review, and that's a little bit less settled law, so I'm going to stick with the 510K process. 510K process relies on a notion of substantial equivalence. So prior to 1976, there was no medical device regulation until the Food, Drug, Cosmetic Act essentially expanded the process and allowed for the regulation of medical devices at that time. And at that point in time, it was decided that everything that was on the market could be grandfathered in. There just were too many devices, too many things out there. And so from a standpoint of 510K, in order to launch a new Class 2 medical device, which can include implantable devices, all you have to do is show that you're substantially equivalent to a device that's already on the market that itself is either 510K cleared or has been grandfathered in. What that means is that device has never been assessed for safety and effectiveness by the FDA, period. The data that is necessary to support a 510K application is generally what they call benchtop testing. There's a ISO standard that looks at the raw materials that are utilized there. It's called ISO 10993, the International Standards Organization. So you do a bunch of benchtop tests, you do some mechanical tests, and maybe you do a couple of animal tests, and that's it. And with that, you get a clearance. And then you can sell a device that is permanently implanted into the human body in some instances. Now, that is all the regulatory requirement that's out there. We believe, among the plaintiffs' bar, that being substantially equivalent, and that could be substantially good, substantially bad, that's not enough, that when you're selling a medical device, just like you're selling any other product, you have to exercise the reasonable care required under the circumstances. And so, looking at the 510K process, there are all sorts of instances where, for example, the predicate device that you're measuring substantial equivalency to has been recalled, okay? So when you're talking about substantially good, substantially bad, you might be judging the safety and effectiveness of that device in that comparative substantially equivalent model to a device that's been recalled or a device that's never been tested. And you get these funky trees of 510K clearance that have nothing to do with the original predicate. And so one of the ways to, so the reason that these cases aren't preempted is because there's never been an agency finding of safety and effectiveness in that absolute sense. So the jury's not looking at the same question that the FDA reviewers are. In fact, in my last trial, we actually admitted as trial exhibits the FDA reviewer sheets. And one of the things that was quite striking is that the word safety and effectiveness never appeared at all on the FDA reviewer's checklist. I was astonished, right? How could you go in and the FDA review this device and never even consider safety and effectiveness? But it did, because it wasn't on the model checklist. And so I think when we talk about Food and Drug Administration and what their conduct is and how it bears on a product liability, we need to understand what is it that the agency is actually doing versus what is it we commonsensically would think that the agency is doing. And in fact, most of the time, juries and heck, lawyers, probably even judges, think that there's this gigantic federal administrative agency that's assessing the safety and effectiveness of every single device that comes its way. But what we see is a large number of recalls. We see a large number of up-classifications. So if you look at pelvic mesh products, it was something that the first MDL to have over 100,000 cases. Those have all been recategorized as Class 3 medical devices after those lawsuits. The FDA expert panel reevaluated as a result of private citizen advocacy and as well as pressure from other groups, and evaluated that it should have been a Class 3 high-risk device. So I think that when we look at what it is the FDA is doing versus what we're trying to litigate on, it's an important question. And that, I think, leads us back to the Bausch case, Stryker case, in this 21 CFR 820. In fact, I am intimately familiar with 21 CFR because it is a regulatory framework modeled after an international standard. And the international standard basically says you need a quality system, but it's up to you, the expert in your field, to implement. We're not going to tell you how to do it. And the underlying thinking behind the Bausch case, in my opinion, is the recognition that when there is an obligation, in this case, an obligation imposed by federal regulation, that just says you have to do something, but it doesn't tell you how to do it. You need to then go about doing it in a thoughtful, non-negligent manner, and that if you are not doing it, that lack of thought, that lack of due care can lead to liability. So I think that that's the ultimate takeaway there. I don't know how I'm doing for time.
No, you're doing fine.
I'm doing for,
Yep.
okay, fantastic. So, just to kind of round out on this, this subject, I think it's important to understand what the case is about and what the allegations being made are. And the analysis really needs to be, what are the elements that the plaintiffs need to prove in their case? And is there a element of that is preempted because of some line of cases? The other topic I want to just briefly discuss is whether or not the 510K process itself, with this finding of substantial equivalency, should be admissible in evidence. And were I to come up here last year, I would have said probably not. There have been a large number of cases where the federal courts, the circuit courts of appeal, I think the Fourth Circuit, the Fifth Circuit, and the Seventh Circuit, have all concluded that it is not reversible error to exclude that information. The idea is that this is not a safety statute. It doesn't set a standard of care, and that's been well established by the federal courts. So then what does it do, right? If it doesn't bear towards the threshold level of conduct that the manufacturer needs to exhibit, and it doesn't relate to the design of the device, what is it? And so those courts have found that it's okay to exclude it, and I would have agreed with that. In fact, I think last year on this panel, I did agree with that. But I just spent 6 weeks of my summer trying a case where it actually did come into evidence. And I'll tell you, my experience was that, first of all, the judge adhered to this New Jersey holding, this Himrock, however you want to pronounce it, McGinnis case. And what that case held is that it is actually error, and this is a New Jersey appellate decision. The court held that it was error to exclude it in toto, and found that the FDA regulatory process, even though it doesn't bear on safety and effectiveness of a device, it's important for a jury to understand that we're not living in a vacuum, and that the FDA does have some real-world impact in real life. And so the jury should at least know there is this thing called FDA and get an opportunity to understand what it is. And so the court there actually found that a measured amount, so that you don't create the sideshow, is the appropriate balance in combination with an appropriate jury instruction. So this summer, we tried a case. The plaintiffs didn't put on any FDA regulation evidence or regulatory evidence as such. We did have an 820 or 21 CFR Part 820 expert to come in and talk about what setting up a quality system means and what that is. And in that case, under 21 CFR, that's the complaint handling system. So if you're not tracking complaints correctly or at all, that certainly bears on safety. That follows under 820. if you're not buying proper materials, that goes under 820.50. You're supposed to have certain material controls. So there's a number of things that come under 820. And we certainly had factual evidence come in from corporate witnesses. We had one expert talk about that. But the majority of FDA evidence came in by the introduction of two witnesses by the defendants. We chose, as plaintiffs, to just cross-examine. And, I actually thought it was helpful. Their experts had to admit exactly what I had represented in opening, is that this statute does exist, that it doesn't find that the device is safe and effective, that it just compares it to a substantially equivalent device, and it's the minimal regulatory threshold. It's a very simple concept. That's what the New Jersey court found. Talking to our jury afterwards, they got it. And one of the things that I have truly come to believe over time is that the civil juries, that at least the ones that I've had, they're incredibly thoughtful. They take the jury instructions incredibly seriously, and they really do their best to adhere to the full letter of the law, regardless of any personal feelings. And I can tell you, this jury, not only did they go line by line through the jury questionnaire, but they went piece of evidence by piece of evidence. And afterwards, we found out, they totally got this issue. They just weren't persuaded by it as being a defense in the case. And so my perspective now, having tried cases both ways, I can tell you that I actually think it helps more than it hurts. And I think that having the right balance of the evidence in at trial provides enough information for the jury to understand that the world doesn't exist outside of a regulatory environment, but it doesn't take over the jury's fact-finding job. So,
Jonathan, can I ask you a question really quick?
sure.
On your case that you had this summer, did the judge impose any time limits or put you guys on a clock at all to get through the FDA evidence?
No.
No? Okay.
He instructed, he told us that he didn't want a sideshow, and he also instructed us, or asked us, what the evidence was in advance, how many witnesses, how long we thought there were going to be, and I think made his decision in a pretty thoughtful way. I have to say, one of the things, just to plug our judge here for a minute, this guy listened to 70 pretrial motions on this one case, and we spent 4 weeks arguing pretrial motions before we had a 3-week trial. So these were not like 2-page motions in limine. They were all these meaty legal issues, and the work that this judge did allowed us to have what I thought was a seamless jury trial, and we will have future. This was one of about 17,000 cases before him, unfortunately.
Did you finish Friday, or are you going back in tomorrow?
Yeah, exactly. So, anyway, I thought the jury really understood the issue and did an excellent job. So,
Thank you, Jonathan. Phil?
Bill?
Thanks. John, Judge Wecht, and Abby, and obviously Don Cochin for putting this all together. Really appreciate, and you all for coming. My name is Phil Goldberg. I have partnership with Carney Bacon, and I chair our national amicus practice. I also am director of something called the Progressive Policy Institute Center for Civil Justice. And when I kind of distill the work that I do, it's trying to help the litigation system work so that it reaches fair and accurate results, not based on the inefficiencies or the gamesmanship or things that, frankly, either side can engage in, but to not let that stuff get in the way of a merited outcome. And I think you all every day in your courts are trying to do that with all the different rulings. And there's a lot of that comes into play in the medical device world. And I thought Abby did a great job laying the foundation of what kind of how the FDA breaks these apart. And then looking at PMA, where normally there's been express preemption based on the 1976 medical device amendments. And so that we haven't seen a whole lot of PMA cases, which I think is why Abby was saying that's been rare. But there's been an effort to kind of make inroads on that. The other issue that comes up a lot is this question of admissibility of 510K evidence. And that's a little bit what frankly thought I was going to be arguing with John about until about 10 minutes ago, and now found out he's been converted. So, but I want to kind of dive into that a little bit, because that's the area that I've been focusing on, and I filed an amicus brief for several trade groups, including AdvaMed, which is the medical device manufacturers, U.S. Chamber, and a couple others. I call it the McGinnis case. There's actually two cases that have been consolidated. I will not try to pronounce the name of the case. I did not file an amicus brief. But I think it's Hrymock, if I had to say it.
Okay.
H-R-Y-M-O-C, Hrymock. But McGinnis works just fine, because they've been now consolidated before the New Jersey Supreme Court to look at these issues that Judge Sabatini wrote about in the appellate division. So the key questions here on this issue of admissibility of 510K evidence is, what context do juries need to have to make the right decisions as to whether a manufacturer properly or improperly brought their device to market? And if improperly, what context they need to decide accurately whether that conduct was so egregious that it warrants punitive damages. And so the juries cannot fairly and accurately make these decisions if they don't know, or not allowed to know, what research and studies the FDA said was needed for their review, how the company interacted with the FDA in meeting those requirements, and ultimately that the FDA cleared the product and gave permission to the manufacturer to sell the product. None of this, I'm sitting here today saying, is determinative, and I think we would all agree on that. The question is, if they don't have this context, it's too easy for them to get it wrong. And so, drilling down a little bit on the regulatory side, on the 510K stuff, just to give it for context purposes of this discussion, why are 43% of medical devices cleared through the 510K process? So Congress and FDA and the American public want device manufacturers to continually develop new technologies. They want the advancements as they come and as new technology is available. And so if you made a modification to a product and had to go back through the PMA process, it would just slow things down and make things too difficult. And it would deprive people of these valuable technologies. And so Congress and the FDA have set up this 510K process to clear products that represent advancements of products that are already on the market. And this is part of critical to the patient care aspect of providing people with these devices. And as you heard, it gives the FDA the flexibility to determine the best path for each device. So what controls are needed for it to be safe and effective for its intended use. And again, to highlight something that Abby said, it's the FDA. It's not the manufacturer who chooses PMA or 510K or Class 1, Class 2, Class 3. It's the FDA that drives that decision-making. If it's new, it goes to the PMA. If it's substantially equivalent to a predicate device and generally Class 2, then it can go to the 510K process. And so what is this 510K process that we keep talking about? So in 1990 is really the birth of the 510K process as it exists today. There was a version of 510K that John was talking about from 1976 that frankly I just wish they just created a whole new section of the code as opposed to just completely rewrite the original 510K, that we wouldn't have this confusion. But today's 510K starts in 1990 with the passage of the Safe Medical Device Act. And it made clear that 510K was a safety and efficacy review. Then they must show that it's the same intended population and use as the predicate, that the technological advancements do not raise different probable benefits and risks as the predicate, and that it must be at least as safe and effective as the predicate. And this process has become increasingly robust over the past 30 years. And in 2014, the FDA said in its guidance that principles of safety and efficacy underlie the substantial equivalence determination in every 510K review. And they continue to say that it is not uncommon for applicants to present significant laboratory, animal, or clinical data running to thousands of pages. The FDA can directs the process. They can ask for more studies, ask for more material, more data. They say about up to 77% of applications, they ask for more information on the first read-through, up to 35% on the second read-through. The approval, the clearance process typically takes about 6 months, and about 30% of devices are not given clearance, according to their statistics. So how does this play out in your courtrooms, in this litigation? The question that you're putting before the jury is, did the manufacturer wrongfully cause the plaintiff's harm? So is the device defective for its intended use? Was the decision to bring the device to market unreasonable? And again, if so, was it so egregious that it requires punitive damages? So how can a jury answer these questions without knowing what the manufacturer did and why when bringing the device to market? And plaintiff lawyers, and I'm sure I know John is a very good one because he litigates against some of my colleagues, are very good at leveraging that lack of information. And so, you hear all the time, they brought this product to market without even doing this study or this clinical analysis. But maybe the FDA said that information wasn't needed, that study wasn't needed in order to get cleared for market. They don't want the jury to know that. They don't want the jury to even know that the FDA exists in a lot of these cases. And so that way, if there's not that information out there, that they can sometimes set the standard themselves. Well, whatever the company did, it was never good enough. Whatever studies they did, they should have done these more studies. And then if they didn't, the fact they didn't do that is a clear indication that they're putting profits above safety. And the defendant is caught in this situation where they can't really defend themselves against those allegations, because they can't say, we talked to the FDA, here's what the FDA asked for us to do. Maybe they said that clinical study wasn't necessary, based on some real world, because a lot of these products, since they're based on a predicate, the predicate has been out in the real world for a long time. And so they can look at what the history of that product has been and then make decisions about the new one. So again, the jury should be able to hear what FDA required of the company. What did the FDA review conclude? Which studies did ask manufacturer provide? Did it say certain clinical studies were not necessary? And was the company responsive to the FDA? I'm sure if you go, when you look at one of these cases at the beginning and you do your FOIA request and you figure out, what was going on between the company and the FDA, if the company looks a little arrogant and is resisting the FDA and not really being very helpful, I'm sure the plaintiffs will say, yes, bring that stuff in. We need all that. But if they look like they're actually doing a good job and trying to do the right thing, then they're, oh no, we don't want that in there. And so our point is, this is relevant and probative to all of these questions, and whether it's good or bad. This isn't a pro-defense or pro-plaintiff position. It's a pro-jury position of making sure that they have the information and be able to make decisions to both with respect to the allegations in the case, but then also the impact that a decision, if a product is deemed to be defective, what does that mean for the product? Does it have to be redesigned? Does the warning have to be rewritten in order for it to be sold? And so if you're forcing companies to go down that path based on faulty decision-making because the people who made that decision didn't have the information that would have helped them, then that's obviously not the outcome that we're looking for. And so, I equate this like if I'm driving 50 miles an hour on a road, and it might be helpful to you to know whether I was being reckless or not, whether the speed limit was 25 or 75. And if I'm doing 50, that might be helpful to you to understand what the government said the road was good for. Now, weather conditions, snow, rain, all that matters too. Traffic, but the speed limit is one data point that is very is important. So if you look at the landscape of cases and the trends that are happening in these 510K admissibility question, there are a bunch of, basically there's been some split rulings. And you have, some of the older cases that are looking at, I'll say this, there tend to be two key pressure points as to which way a court will rule. The first is, what is 510K? Is it safety and efficacy? You heard John say that he didn't think that it was, and you've heard me say that it is. And so the courts that have looked at this, that have said no, it's not safety and efficacy, are looking at a Supreme Court ruling, Medtronic v. Lohr, which was assessing the 510K process in the 1980s, before the 1990 Safe Medical Device Act. And so it's easy to go to the Supreme Court, like that ruling, and say, oh, well, the Supreme Court said not safe and efficacy, so therefore it's not relevant or probative to whether the device is safe or effective. the courts that are allowing them in, and the trend has been over the past few years to admit this evidence, as you heard from John, and they're taking a fresh look at this and saying, okay, what is the 510K today? What has it been since 1990, if that's the appropriate time frame for the device in the case? And they're saying that is a safety and efficacy review. But either way, it's clearly relevant and probative to, did the manufacturer act reasonably? Is the manufacturer should be subject to punitive damages? So at the very least, if you're looking at negligence or conduct-based claims, it's relevant and probative, and it should be admissible. If you're looking at defect, I do still believe it is admissible, but that's, I think, where you get into that safety and efficacy debate. And courts have, again, been saying that, while not made to be dispositive, the 510K process is nonetheless relevant to whether the company defectively designed the device. It is relevant to put in context the relationship between the 510K process and the safety of a given device. And ironically, we were doing one of these conversations about a year or so ago, and someone had mentioned that in the Laura case, the application, the PMA was 1,100 pages or something like that. Well, the average 510K submission today is 1,100 or 1,200 pages. So even if you're comparing to what the PMA was back in Laura, it's not the same rigor as a PMA, but it does have a lot of rigor to it. The second pressure point that we see is prejudice, right? Is admitting the evidence, even if it is relevant and probative, does it prejudice one party against the other? And again, the cases that say that don't allow it in say that having the FDA kind of give its stamp to the product might be prejudice against the plaintiff. But this New Jersey case, because I'm very familiar with it, was very clear in saying, no, the unfairness occurs if the information cannot come in. It can deprive defendants of a fair trial by giving a skewed impression of the facts. Jurors could assume defendant recklessly sold their defective products to the public without any restraint or oversight whatsoever, and this unfairness is most pronounced with punitive damages. This issue that Abby and John were just talking about like what did it look like? That's another question that comes up in terms of, is it limiting instructions? Do you have a 3-4 hour motion hearing on this? Do you have nobody wants a sideshow, but everyone has agreed the courts have agreed that have allowed this in. The trial judge can do that. They can set up the right parameters to make sure that this doesn't get out of control. And we trust juries, and I'm sure you've seen this a lot in your courtrooms, with applying government standards all the time, in risk utility tests, product liability claims, what have you. And we don't think that these government standards should be treated differently. I will say in the New Jersey case, at least the McGinnis case, one of the reasons that the appellate division was so concerned about the justice that was done in that case was that because the plaintiff's lawyer was allowed to say, I think it was 26 times, I could have the number wrong, that the manufacturer didn't do what was required, and that it referred to the device as experimental because it hadn't been approved, it was only cleared. And the defendants found that they couldn't put any of those words into context. And so, anyway, so just in sum, juries can issue more fair and accurate liability decisions when they have this information. Context matters, and we do believe that juries should have access to the information because you can't tell the story of somebody's harm without also being able to tell the story about what was done on the other side.
Thank you, Phil.
So, can I just comment on the other side?
Sure.
So while I've had a very good experience where the evidence does come in, I think it's important to understand when it has been excluded, there's a reason for it. And that is the FDA, and there is, to my understanding, with the exception of, I think, a Western District of Pennsylvania case, it might be Eastern District, there is no federal appellate case that has ever said 510K is anything more than substantial equivalence. Period, hard stop. The federal courts have unanimously, as recently as the last time a federal court has decided it, concluded that it is not, and in fact the New Jersey decision recognizes, it is not a safety statute as such. While it is true that the regulations say notions of safety and efficacy are inside every determination, what it looks at is measures of substantial equivalence. The evidence in cases where FDA is out from evidence the parties still admit the evidence of the underlying testing. So if someone comes in, and so in the Primark case, the plaintiff's counsel made an argument that they had done no pre-market testing on people. There was no clinical trial of a permanent implant into this person, and that they should have done human clinical trials. Well, the FDA doesn't require human clinical trials, and that's part of the FDA classification scheme, but it doesn't mean that reasonable care doesn't require it. And it doesn't mean that the company shouldn't have done it. It just means that no one said they had to do it. And so whether you agree with the way that the case was decided or not, that's the difference. And so I think when we look at the evidence that comes in, the jury's job is to look at the data and actions of the company. Did this company fulfill its responsibility to make sure that this device is safe? What testing did the company do? Was the data that the company relying upon, was it reasonable, even if it didn't do human testing? Did the company have a good reason in science to not do that? Those are the real questions that are left for the jury, that should be left for the jury, because that's what the law as developed stands for. When I said earlier, I've talked about my experience, I've been able to put that into evidence through both the defendant's witnesses and the jury instructions. And so I don't have a problem with this notion of just everything coming in, because I'm confident in my facts. But when we talk about these devices going through this process, a lot of times these products that go in as a 510K bear little to no resemblance to the device that existed the generation before. And one example I can give you, well, if you look at either pelvic mesh or abdominal hernia meshes, two easy examples. Back in 1976, mesh looked like a fishnet, okay? That's what it was. But we've gone so far now that you have 3 and 4 different types of plastic mesh attached together. You have permanent rings and nonstick coatings and fish oil and all these other amalgamations, things that no longer even closely resemble the original product. And so it's hard to say that these companies did their due diligence in the few examples I'm giving when they're so far different than what the FDA originally was looking at. And what they're doing is they're moving slightly to the right until, 30 years later, there's completely different uses and completely the applications are completely different, because companies can say, well, it's a hernia mesh repair product. The products that are sold today go up against the bowel and the internal abdominal organs. Early products never did that. So no FDA reviewer has ever said, well, how does the body of pre-market data that relieves you of the obligation to do human clinical trials, how does that match up to the indication here? And these are all the kinds of things that we put on in evidence. Again, I find it helpful to have the FDA piece in, because I like to juxtapose what's happened over time. But I can see why the courts have held the other way, and I've tried cases the other way, and I felt that at the time, really central to the analysis, the jury heard everything it needed to hear. And I still believe that. I still believe that to decide whether a device or drug is safe and effective, you only need to look at the evidence in front of you to meet the jury standard. Whether that background is necessary or not, I'll leave that to you all.
Thanks, Jonathan. We'll go Abby and then see if either of you gentlemen want to respond.
One thing I was thinking is, since a lot happened since you spoke. I was making notes and now I forgot what I was going to say. But one thing I wanted to point out, with regard to the 510K products, or the products that are cleared through a 510K, those products have been in clinical use long-term. And so there are many, many studies that have been done since they've been used. that the FDA has access to, that we all have access to, that we can look at, that we use in trial in every case. And so it's not like there haven't been any studies or there hasn't been any information gained about how these products actually do when implanted in a person. So they're not just considering that in a vacuum. I was going to say something to you about pelvic mesh. What did you say they've changed a lot over time? Is that what you were saying?
Right, there's been, so even, well, meshes generally, right, but I think that holds true with pelvic meshes coming from the original Protogen.
Yeah. So that reminded me, I also work on pelvic mesh cases, obviously on the defense side, but that occupies actually probably about 75% of my time these days, which is hard to believe because the pelvic mesh litigation's been going on since what, like 10 years maybe, something like that. But I still have a lot of those cases that I'm handling. And, he mentioned that they were reclassified, but pelvic mesh slings are still on the market. They're still being used every single day in the U.S. And the FDA has recognized that they are a standard of care. All of the gynecological and urogynecological groups have issued, not all, but many of them have issued position statements where they refer to midurethral polypropylene slings as the gold standard for treating female urinary incontinence. So that's just sort of the flip side of what Jonathan was saying.
Just to give a shout out to Phil for a second, if I might just take 30 seconds to talk about your firm and how. So I litigated vaginal meshes from the beginning with Phil's firm, and my son had surgery. This is going back; he was very young, and your firm sent the most gigantic package to him in the hospital, and I never forgot that. And so I just have to give that story, real classy folks.
You know why, John? Because litigating against you, they have charged such high fees.
That's right.
They give all the active plaintiff lawyers big prizes.
That's right.
I can't touch that. All right, so, but one of the things that John said earlier is about, reasonable care, and that's the job of the jury, and I think we all agree with that. It's just about what information the jury should have. And if there wasn't a clinical study done in the example, maybe it was because, the predicate product had been out in the marketplace for a number of years, and they didn't feel that the new product was that, it was obviously substantially equivalent, and that the data from the existing real market world was better or as good as any clinical study would have been. And so it's just a question of helping the juries understand that. Again, that's not determinative. It's not going to say, well, if the FDA said no clinical studies are needed, forget it, no clinical studies are needed. But it's important information for the juries to know that they didn't do it because the FDA said it wasn't necessary, maybe why the FDA said it wasn't necessary.
Can I ask you folks, all three of you, this? The Bausch case, the one that the panel's been talking about, was review of a 12B6 dismissal. But listening to you folks talk about these trial issues makes me wonder what suggestions would each of you have for the judges here on best practices for motions in limine in this area, because it seems like there would be a lot of important jousting to be done in limine motions, number one. And number two, jury instructions, because certainly they're not going to be suggested standard instructions, at least I haven't ever seen them, on 510K or, and have you been successful in your cases in negotiating proposed points for charge with opposing counsel that can be agreed upon? So those are just two, the motions in limine and jury instructions seem to me to be two areas that are potentially challenging for us.
So, speaking from my own personal experience and having tried half dozen mesh cases, including one this summer, I will tell you, I think we waited until motions in limine to really broach this issue and the meat of this issue until trial. I actually think that an education day might have been, or some sort of educational presentations by the party, just as to what their view of the regulatory structure was earlier in the case, much like we do Science Day in some of these complex litigations. I actually think that might assist the judge at least to understand where the battle lines are. There are so many areas of agreement, but there are some major areas of disagreement that really do come out. It's those areas of disagreement that end up becoming the subject of motion practice and prevent the agreement from agreeing on a proposed set of jury instructions. And so I actually think that dealing with the issue earlier will allow both parties to frame their cases from the beginning, because I think it impacts how you do a doctor's deposition, how you do the experts. Everything has a ripple effect on the case. And so that would be my big recommendation, is to treat it like Science Day, hear what the parties have to say early on.
I actually agree with you on that too, because I think litigation obviously is very expensive and it's time consuming, and having something sort of akin to a Science Day or having it be presented along with the science issues, I think would be incredibly instructive to the lawyers and helpful to the judge, and I think it could really help streamline what discovery we end up taking and what experts we end up using. I mean, a lot of times we've hired regulatory experts and we never use them at trial, but we end up working extensively with them. Sometimes they get deposed, they're the subject of Daubert motions. So there's a lot of work that goes into preparing sort of on all fronts. And so if you did know early in a case sort of where things were heading, I think that would be helpful.
So I don't litigate. I'm an amicus lawyer for most of my day job. So I probably can't offer too much on the motions in limine. I will say in the McGinnis case, there's been a lot of talk about jury instructions and when would be appropriate. It doesn't make sense to wait to the end of the case. Maybe when the evidence is going to come in would be more appropriate. There's even a discussion, maybe just the judge provides a jury instruction what 510K is and don't even allow the experts in. There's probably a lot of different ways you can go about doing it, but probably having a hearing and deciding given that specific case what the appropriate restrictions on the evidence would be and what the appropriate jury instructions would be, and then obviously if whatever said during trial, making sure that those statements are put into those contexts as they come up.
I know in the Bausch case, folks, that Abby talked about, that in that diversity case, they had common law negligence and strict products counts. And I wonder if in your experiences, you've had significant amount of battles over whether or not you can get to the jury with a negligence per se instruction. Because since we're talking about FDA violation in Bausch, that was such a key issue, whether that's been an important issue in trials in this area.
So from the plaintiff's perspective, unfortunately, or maybe fortunately, depending upon your perspective, I don't think that negligence per se applies to 510K because there's no true violation of a federal statute or state statute on the safety mechanism. When you get into, so there's two aspects of things, right? So there's the regulatory clearance process, or how do you get to market? But then there's the set of obligations that someone has when a product is on the market. And those are very similar regardless of the path that you take to get to market. And 21 CFR 820 actually applies to both kinds of products. And there, I think you have more of an argument that it does apply because there may be an FDA finding out there that you have a product that is either misbranded according to the FDA regulation, or you fail to use good manufacturing practices and get what's called a 483 letter. There's more of an argument there, but again, I question none of the 820 standards are prescriptive in the way that they're applied. They all give a structure like a bones without actually filling in how to actually do something. And so personally, I don't know how you would charge that unless you're seeking to connect the violation with, and that there's a cited violation with the injury. And I don't know how the body of law deals with that, quite frankly. I've not seen that actually ever happen. So, but under my ordinary circumstance of cases, I don't know that it would be a good fit.
Because
Yeah,
the reason I ask is in this Bausch case that we're talking about, it was a bad hip replacement. And the Seventh Circuit discussed how that was adulterated and the manufacturing process failed to comply with federal standards. That what made me think that they were trying to get to a jury in that case on a negligence per se, as well as strict products and negligence.
Yeah, I think that is what they were trying to do. Yeah, it's something that I actually have never encountered in my practice. I may, in this case, I've been talking about my own case. We deal with that. I haven't yet.
One more question I have for you, and hopefully other people have some questions, but Donald's thinking up a really difficult one. But I wonder if any of you have received feedback from jurors post-trial in any of these cases that might be instructive for our judges here as far as how to handle matters like this.
So I have, and I hesitate to tell you, and I wasn't sure if I wanted to tell you or not, but I will put this out there. We had a jury trial several years ago where it was decided, in fact, I think we agreed, I think the parties agreed that we were not gonna talk about FDA evidence. We weren't gonna bring in 510K. It was sort of a deal we struck. There were some things that weren't gonna be coming in from the other side either. We won the case. And we polled the jury afterwards and became very clear from our discussions with them that they assumed that the product had been gone through a full safety and efficacy review and approved by FDA. Otherwise, it wouldn't be on the market. And so that's something that has always weighed on my mind whenever we talk about these issues, because quite frankly, before I got involved in all this, if you'd asked me, I would have said the same thing. I would have not ever known the distinction between the two pathways. I wouldn't have understood, what the FDA, this whole question of substantial equivalence, I would have had no idea. And so I think that is something that we can't ignore, and we do need to think about carefully.
One thing that I think is worth mentioning, because so much emphasis today has been put on what does this regulatory thing mean, and how much does the jury concern itself with it. In this case that I tried over the summer, the product had been cleared in 2000. The client hadn't been implanted until 2008, and his injury manifested in 2018. So we weren't talking about a product that was new to the market. So in my view as plaintiff's counsel, I didn't want to try a 2000 case, right? In my view, the evidence had been so well developed in the intervening 8 years that it really didn't matter what that company did to get the clearance. And I think that we like to spend as lawyers so much time talking about it, and I don't think the jury, having polled the jury afterwards, I don't think that they really were persuaded, because they knew that there was this huge morass of data that had come in the intervening 8 years between the time the product was launched and the time that my client was actually implanted and then certainly harmed, that they could have changed their course of conduct. And so it was very much like, in some regards, my grandmother had a Plymouth, a 1967 Plymouth that she drove into the 90s, and it didn't have ABS brakes, and it didn't have seat belts, and it didn't have all these other features to it that we would consider in the 90s state of the art. But she would have told you that that car was safe, and you couldn't sell it in that era. And that is sort of how the company felt in this particular instance. They were talking about a product that had seen its better days, didn't keep up with the times, and that was the theme of our case, less so whatever they knew or did 8 years earlier. So I don't want you all as jurists to think that this clearance process is the end-all be-all. Really, it's a starting point, but not the end point of what was known or should have been known by a responsible company.
Have any of you seen a case or been involved in a case when a company tried and perhaps was successful in avoiding this entire FDA clearance process by convincing the relevant agencies that it's really not a device within the meaning of the Food, Drug, and Cosmetic Act? That it should be channeled elsewhere?
Oh, there's, yeah, so actually, the Paragard birth control device is actually being litigated right now as a PMA drug. And I can't tell you the reasoning why. I just know that that exists, and somehow, and I don't know if it has a drug release in it, and that's why it's being dealt with as a PMA product, or PMA drug, not a device, even though the failure mechanism in that case is that one of the arms is breaking inside women. So yeah, that's the only example I'm actually aware of.
Yeah, because over 30 years ago, when I was practicing law here, I remember I was working on a matter when the firm I was at was hired by a tobacco company, and I looked it up to refresh my memory. They had developed smokeless cigarettes, and it was going to be the first commercial heated tobacco product. Does this ring a bell? And the firm I was with was trying to convince agriculture to regulate it instead of FDA, on the theory that it was agricultural and not a drug device. And ultimately, it was so difficult to use and tasted so unpleasant. It was just yanked. It was a commercial failure. But I thought it was an interesting, because obviously, if you're the manufacturer of a tobacco related to, you're going to want to be regulated by the Department of Agriculture, right, and not by FDA. I don't know if something like that would have an implication in a lawsuit, if that could come up.
What we're seeing now is probably that debate over computer programming and apps and things like that. Is the app a medical device, or is it just an app? And so if there's lawsuits over that, well, does it have to get approved, cleared, whatever you want to say, from FDA? There's also a big question about AI in medical devices, because if the AI allows the device to change as it's in use, does that mean that you have to get approval every time the AI kicks in and it changes something that the device is doing in terms of, what kind of dose it's giving out, or what time of day, or, whatever it is? And so there's a lot of questions, I think, that are at the forefront of kind of technology right now. Maybe John knows a little more about that.
Well, it's interesting. Yeah, actually, oddly, I do. There was a Class 1 recall, I believe, of a product last year where it was a software app interface. So it was with a device called the Dexcom G6, I think it was, which is a diabetes, blood sugar, continuous glucose monitor. And there was an issue with the app after 30 days being on your iPhone. I think it was unique to the iPhone. I'm not 100% sure. But it would stall out, and the alarms, the very purpose for having the device, stopped working. And so Dexcom issued a Class 1 recall, which is the highest classification of recall the FDA does. I believe FDA has a guidance document now on apps in medical devices, but I don't know that there's anything beyond the guidance document itself. So, apps are one of these things, generally speaking, where it's huge questions. I won't get into social media and 230 and all that stuff, which will be all coming everyone's way pretty soon. But it's, I think on the medical device, the FDA at least views itself as being the regulatory body that controls them.
That might be a topic for next year.
Yeah. You got that, Don?
thank you all very much. I think our time is up. Thank you very much.
Yeah.